Hi, welcome back. Today I've got two videos for you, hence the magical change of clothes you'll see in a minute. The first video right here, right now, is on two topics, which is the difference between a magistrate's trial and a Crown Court trial, and the second topic being what is a joint enterprise. And the second video is a story from the poll that over 700 of you voted in, so thank you for that. So 20% of you voted for why I've never worked for anyone else. So that video is going live today. That's linked below. In the meantime, on with today's show. The first of those is to explain a magistrate's trial and how that compares with a trial in the Crown Court. So first of all, just to get the terminology right, it is a trial, whether it's in the Magistrates Court or whether it's in the Crown Court. Some people, certainly on my channel, have referred to some instances as a hearing. Now, the difference between a hearing and a trial, you can think of it as the trial is where the court hears the full evidence and comes to a decision. A hearing might be on a very discrete issue. For example, bail, that can be heard in the magistrates or in the Crown Court, or in a civil matter, an application can be heard, whereas that might not be the full trial. Those we would refer to as a hearing. But where the court hears the full evidence, in other words, in a criminal case, the prosecution's case and the defence case and any witnesses that are necessary, all of that would be considered a trial. It may happen in a matter of hours, it might happen in one full day, it might be several days, or it might even be several weeks, or even months in the most complex cases. First of all, you should know that a trial in the Magistrates Court and the Crown Court broadly follow the same procedure, although there are procedural differences in the Magistrates Court to the Crown Court, and the main differences are what I'm going to focus on in this short segment. Now, there are two principal differences between the Magistrates Court and the Crown Court when it comes to criminal trials. The first of those, which should be relatively obvious, is that the Magistrates Court tends to deal with the less serious cases and the Crown Court broadly deals with more serious cases. I say broadly and generally because if an offence is what we call an indictable offence, that means it can be heard in the Crown Court. But it can also be heard in the Magistrates Court, and that depends on a couple of things. First and foremost, it will depend on whether or not the Magistrates Court accepts jurisdiction. In other words, they will have a summary of the facts and the seriousness of the case and make a decision as to whether or not it should be going to the Crown Court. If that decision is made straight away, then the case will be sent forthwith to the Crown Court and the defendant will have no choice. This is known as the Magistrates Court declining jurisdiction to try the case in the Magistrates Court. A situation where a case might end up in the Crown Court but start in the Magistrates Court is where the Magistrates Court accepts jurisdiction and tries the case there, but then on the conclusion of the case decides that its sentencing powers are not great enough and the defendant should be sentenced by a Crown Court judge. So then the case is sent at the conclusion to the Crown Court for sentence. This is known as sending a case to the Crown Court for sentence. If an offence is a summary-only offence, then it can only be heard in the Magistrates Court. Whereas if it is an either-way offence, which means it could be heard in the Magistrates Court or it could be heard in the Crown Court, or it's an indictable-only offence, those are offences that can be tried on an indictment. That makes them indictable. If an offence is either way, that means the defendant can elect Crown Court trial even in the event that the Magistrates Court accepts jurisdiction. So you might have that scenario where the Magistrates Court has said, yes, we can hear the case, but then the defendant elects Crown Court trial and then is tried by a judge and a jury. There are, of course, some more rules and exceptions, such as the age of the defendant, whether the defendant's being tried with someone else, for example. I'll go into more details in another video for those, but this brings us to the second principal difference between the Magistrates Court and a Crown Court. In any case, civil or criminal, there are going to be what we call findings. There's going to be findings of law and findings of fact. A finding of law will be a decision on how the law applies in this particular case. A finding of fact is going to be when evidence has been heard by a court and a decision has been made as to what actually happened. This is known as a finding of fact. For example, whether or not a person was at a given time at a given date is a finding of fact. Whether a given person did a certain act in a certain place at a certain time is a finding of fact. So the court would hear all of the evidence from different witnesses, perhaps CCTV evidence, perhaps documentary evidence, DNA evidence, all of those kinds of things, and the court is going to make a finding of fact as to what actually happened. These two findings, the finding of law and the finding of fact, come together so that the court can make a decision. Now, the court, in terms of the Magistrates Court, is made up of either 3 magistrates or 1 district judge, a district judge being a full-time professional judge. Now, in the Magistrates Court, these 3 magistrates or the district judge will be responsible for both the findings of law and the findings of fact. In other words, you have the same tribunal, the same panel, either the magistrates or the district judge, making findings of law, in other words, whether a piece of evidence is admissible or not. So in the scenario where there is some evidence, but there's legal arguments as to its admissibility, those magistrates or the district judge may rule that that evidence is not admissible in the trial. However, those magistrates or the district judge will also be responsible for the findings of fact in the same case. And this is the second principal difference between the Magistrates Court and the Crown Court. In the Crown Court, it is the Crown Court judge who is making findings of law. However, it is the jury that make findings of fact. This is the fundamental difference, in my view, between the Magistrates Court and the Crown Court. In the Magistrates Court, a prosecutor need convince the magistrates or a district judge of a finding of fact, whereas in the Crown Court, the prosecutor needs to convince all of the jury, or a majority, with a majority ruling from the judge, of a particular finding of fact. In other words, if the prosecutor wants to convince the Crown Court that a particular person was in a particular place at a particular time or did a certain thing, it is the jury that this prosecutor needs to convince beyond reasonable doubt, or, as the direction goes, so that the jury are sure that that is a fact put forward by the prosecutor. And conversely, the defendant or the defendant's representative in a magistrate's court needs to raise sufficient doubt for the magistrates or the district judge. And in the Crown Court, the defendant or defendant's representative need only raise sufficient doubt for members of the jury as to whether or not a certain thing happened or a certain fact should be found. The starting point for a jury is that all of the jury members should agree on a verdict which are put forward by a single person. Only when what we call a majority direction is given to the jury by the judge will the judge and the court accept a majority of the jury on a particular verdict. But again, I'll go into more detail about specific jury findings in another video, so join me there. The second topic to talk to you about today is that of joint enterprise, or as it's sometimes known as secondary liability. You may have heard terms where someone is an accessory to a particular crime. So if there's a robbery, someone may be an accessory to robbery or an accessory to burglary, and so on. Generally, the way this works is that there is a principal actor, the main person who is carrying out the crime, and someone who is helping this main person carry out that crime. For example, the getaway driver, the lookout, or someone else who is generally assisting or contributing or participating in that principal crime. There was a fairly recent case in 2016 where the Supreme Court got involved to restore the mental element or the intention behind parties in what we call secondary liability or joint enterprise. But again, more analysis on that in another video. The main point to take away from this brief overview is that if two parties come together to agree their roles in a particular crime, even if one of them has a lesser role, but jointly they've agreed that the outcome is that a particular crime is going to take place, with either one of them being the principal actor, then both of them are going to incur some liability. One exception might be where the principal actor has gone far beyond what they had agreed their respective roles were supposed to be. So there you go. I hope that was an interesting summary of the difference between a magistrate's trial and a Crown Court trial. Don't forget to check out my story linked below that 20% of you in the poll voted for. Thanks for watching, and I'll see you next time.